motion and you are here today, this is a mandatory appearance docket. Have you received discovery in the case?
They gave me some discovery. They didn't give me the things I requested.
What did you request that they didn't give you?
I don't think they gave me anything I requested.
What did you request? Were you shown the office report?
If you remember, Your Honor, we went through everything on the record. Everything I had was provided, and I went in detail on the record.
We actually had a discovery hearing, and it's all on the record what was provided to you. What is it that you think you are entitled to that was not provided to you?
I didn't get any Brady material.
Brady material is evidence that is exculpatory. Do you possess such evidence?
No, Your Honor, everything that's in my possession, Mr. Davis has.
All right, she doesn't have any. Next.
I mean, all that she gave me was a bunch of opinions. I didn't get any facts.
Did you see the offense report?
I don't see anything in there that was a fact. It was just opinions.
Which is why you have a right to have a jury trial, to have evidence offered and live testimony. What next? You know who the witnesses are, correct? You know who they're saying they're going to call as witnesses.
Again, this is all stuff that I believe we're supposed to provide these facts before they even file this.
You're wrong. Next.
Okay. What about my motion?
Urge it. Urge your motion. You filed a motion. You're
Okay.
representing yourself. Urge it.
Do they have a response to it?
Urge it first, then they can respond.
What do you mean by urge? You want me to read it to you?
No, it's a legal term, which means you said you wanted something. Now you have the opportunity to request that of me.
Okay, I would like you to dismiss this for the reasons I listed in my motion to dismiss.
State's response?
We're not going to ask you to dismiss this at that time. We have enough probable cause to go forward, hence we're here. We need to either set it for a jury trial or, I think we just need to set it for a jury trial, Your Honor.
Do you wish to offer any evidence in support of your motion, sir?
What I've listed in it, yes.
That's not evidence, that is typed words, as you say. Do you wish to offer the court evidence to support your motion?
It is all just typed words, and but these are all court cases that, you know, I thought y'all follow
Do you
these.
want me to rely on your motion to make a ruling? Is that what you're asking?
Have you read it?
Yes, I have.
Yeah.
All right, motion denied.
On what grounds?
That it's wrong, that your belief that this case should be dismissed is incorrect. I am denying your motion, and judges do not have to explain themselves to lawyers or to defendants representing themselves.
So your decision is arbitrary?
Your motion is denied. What next?
Have they filed a valid cause of action?
You had a formal arraignment in which you were read your information.
So this
You were
court,
formally charged in this court. The state stood up, read the information, and you entered a plea of not guilty.
no.
I entered it for you because you wouldn't do anything. I have that right. If you do not wish to enter a plea, I enter a plea on your behalf of not guilty.
Twice I've tried to plead guilty, and this is the first time I've heard that somebody's entered a plea on my behalf.
Okay, you're telling me you want to plead guilty to these charges.
As long as I'm informed the cause and the nature.
See, you don't really want to plead guilty. You're challenging this court's authority to even hear your case. So when you challenge the jurisdiction and authority, I can't let you plead guilty because you don't really want to plead guilty.
I do. I'd like it to be explained to me what the facts are. And all I've gotten is opinions.
Sir, this is how it works. You read an offense report, you look at your discovery, and people make decisions as to whether they want to enter a plea of guilty to a judge or whether or not they want a jury trial. There's not much in between here. You either want a jury trial, or you want a bench trial, or you want a disposition. Those are the options.
facts have they provided?
Sir, we're not here about facts. That would be
Well-
a jury trial.
Aren't facts being presented part of due process?
Sir, I'm not going to argue with you.
I'm not trying to argue.
This is a hearing in which two things occur. I asked if you've reached discovery, which I already had a discovery hearing, and I'm asking you now if you are rejecting the state's offer of disposition.
That they offered me the first time I came here for probation?
Yes.
I don't see why I should take that.
Okay, so you're rejecting the offer. So the next step, and the only thing that happens today, is I set your case for trial.
Even though every time I've come in here, I'm trying to plead guilty.
You're not really
Ha-
trying to plead guilty. This is what, every time I say you want to plead guilty, you say, well, nobody's shown me any facts. Nobody's established jurisdiction. That's kind of how I feel, but you can't do it.
Am I presumed innocent?
Yes, sir.
How can you presume me innocent while assuming that these codes apply to me?
Well, what?
The first time I was in here, you said that you already assumed that the code was applicable to me.
Sir, you're in the state of Texas. We have a penal code.
Are there facts to go along with that?
Your body was in the state of Texas, in the county of Gregg, if they proved the county of Gregg. And so, yes,
You're already assuming that those are facts?
I'm assuming I have jurisdiction over you. Now, that could be proved wrong if it turns out that your body was not here. But at the moment, yeah, you're in my jurisdiction.
Isn't jurisdiction an element of the crime?
This is not the time we argue about this, sir.
I'm not arguing, I'm
Yes,
asking.
you are. This is a
I want to
mandatory
plead guilty.
appearance.
I want to plead guilty. So how come?
Okay, cause number 2014-1784, the state of Texas versus William Michael Davis, to the charge of driving while intoxicated. How do you plead?
I have an unsigned plea of guilty. I'd like to be informed of the cause and the nature of these charges.
Sir, you have been formally arraigned. The information was read to you. You have had a formal discovery docket. You have rejected the plea agreement, and we are setting your case for trial. So, what date would you like to go to trial?
So far, I'm going to object to everything that's gone on so far.
Oh, I'm sure you will, but now we're going to select the jury trial date because this is how you want this case to roll.
I think Monday I'm going to have to file a motion to ask you to recuse yourself. You're assuming essential elements of a crime.
You can file whatever motion you'd like, sir.
Okay.
Quiet over there.
But I'm setting you for a jury trial, so please select a date.
Probably some time out then.
We usually go within the first 2 months following a docket, so I'd like you to select a date in either September or October.
The dates available are September 15th, 22nd, 29th, October 13th, 20th, or 27th.
27th of October.
State agreeable?
I'm sorry, what was that date wrong?
October 27th.
Yes, Your Honor.
Sir, you are set for October the 27th for trial. Once again, I'm going to suggest to you that you need a lawyer.
So they can start waiving my rights.
I'm just going to suggest to you that you need a lawyer because you're going to trial on an offense that carries up a potential 180-day jail sentence. That's all I can do is tell you that you really, really do need a lawyer. And if you do not ask me for an attorney or hire a lawyer, then there's nothing I can do but set you for trial. However, as strong as I can, I've suggested that you need a lawyer. So I guess I will see you on October the 27th, but should you change your mind and decide that you would like a court-appointed attorney or you've hired an attorney, please advise the court.
Okay. On the record, I still object to you entering a not guilty plea for me.